next matter to come before the court is Catherine A. Dipalma versus Douglas B. Whipple. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, if you let me know when you get started, I'm keeping the clock this morning, but you can also reference it on the wall. Please don't use the names of any victims or minors. I don't know that that's relevant here, but it's a good thing to continue to repeat each time. Because the court is recording this session and it will be posted on, it will be posted on the court's YouTube channel. The judges have read the briefs. We're ready to see when they are.
Good morning, Your Honors. If it please the court, I'm Douglas Whipple, the appellant, representing myself pro se. I wish to reserve 4 minutes for rebuttal. On page 10 of the journal entry, the magistrate stated that defendant, me, can still work and is not retired. This finding was not accurate. I'm now 69. I was 68 at that magistrate hearing on January 11, 2022. The magistrate acknowledged in her findings, quote, defendant will have no remaining clients or ongoing business after December 31, 21, close quotes. At the hearing on January 11, I testified that I had not actively practiced after October of the previous year. I had 3 cases that still needed to wind up, but they wound up in December. I had no cases or clients by the end of the year, by December 31st. And I had no legal fees whatsoever in the year of 2022. That testimony was not disputed. The supplement to the original motion, and this was filed in December, stated in writing before the hearing that I would have no further active law practice after December 31, 2021. That retirement date was 11 days before the magistrate's hearing in which I testified.
At the hearing before the magistrate, had you produced all of your business records so the court was able, and the other side was able to ascertain whether you were in fact still working in the year prior?
The short answer to your question, Your Honor, is yes, I had. There was a dispute about documents that were not produced, and that is not an issue that I've raised on this appeal. But all of the documents that were relevant to the guardianship, relevant to my father's probate estate, or relevant to any income I received either through the firm or through myself individually, those documents were all produced.
What I understood from the decision and the record was that you created your own document to say, here's what I received from these entities, the guardianship of the estate, rather than filing the final accounts or partial accounts from the estate with the guardianship to show exactly what you told the court. Did you give the records from the court to the other side and submit those at the hearing before the magistrate, or just something you yourself created to show, here's what I made?
Your Honor, my answer is that I did give those. Now, this Exhibit T, let's go with Exhibit U. Exhibit U did provide all the information about monies I've received from the guardianship. Exhibit T was also submitted to the court, to the probate court. So the probate court would know, even though it wasn't particularly required, how much I had received from transfer on death accounts, how much I had received from payable on death accounts, how much I had received from the guardianship. I did provide that to the court. It was not on a probate court form. It was attached to a probate court form. Has that answered your question, sir?
Yes.
Okay. The original Do you have a question? The original spousal support motion that was filed May 2021 said I was winding down my practice, but that sentence came immediately after the reference that my voluntary retirement at age 65 is considered change of circumstances. There was no question, and I think respectfully magistrate misinterpreted. There was no question that when I said winding down, that meant winding down so that I will no longer practice law. That's what I said, that's what I meant. Not, I was reducing my practice, but I was in fact winding it down. As I've mentioned, anything referring to the issue of retirement, or whether that's a change of circumstances, is it governed by contract law, and it's for your prerogative to do a de novo review of that, and also it was the requirement of the trial court, and respectfully of yourselves as well, we should apply the ordinary reasonable meaning of what does it mean to retire.
Wouldn't it actually be an abuse of discretion standard that the magistrate found that you weren't in fact retired?
Forgive me, that I was in fact,
The magistrate found that you weren't retired, that you intended to retire, that you were winding down, and that you still have the capability to practice law.
the answer, Your Honor, is I think if you review de novo, you would reach that conclusion. Magistrate was wrong. If you look under abuse of discretion standard, you would reach the same conclusion. There was no, the only evidence on which the magistrate relied, and I believe was insufficient, was that I had submitted an application for retirement, and that application for retirement was never ruled on. But going back to the divorce decree didn't say you must, it's change of circumstances if you retire and submit a retirement application to the Supreme Court. It didn't say that, it just said retire. That means no cases, no clients, no income. Did that answer your question?
Yes.
Okay. So the record shows that I met the age requirement. And something that's very important here, and was not properly thoroughly discussed by the magistrate, is the amnesia. I won't have it every day, I won't have it every month, but I can't go into a trial, to a jury trial, at the risk that I have amnesia in the middle of the trial. I can't enter into negotiations for my client at the risk that I won't have another episode. I just have to retire. Medically, I have to retire, and that is beyond dispute, regardless of what anyone else should conclude. So, in summary, assignment of error number one, am I retired? Whether under abuse of discretion, or whatever, should be sustained, and the case should be remanded on that basis. Now, with respect to the evidence of distributions from the Paul Whipple account, and Judge Stevenson, I did address your one question in that regard. I hope that it is clear, it certainly was not clear to the magistrate, that with respect to the Chase Bank checking account, this is my own personal checking account, ended in 368. That was where I deposited all monies from my father's estate and all monies going out, in or out. The magistrate said, and this was absolutely a mistake, that I produced no documents prior to December of 2020. The truth is, I had not provided my savings account records as of prior to that date. I had not provided a guardian checking I had for another ward, but I had provided each and every one of the monthly bank statements for the checking account 360. I provided them in discovery, but as you understand, Your Honors, discovery and evidence are two different things. Mr. Donor didn't put all of those monthly statements into evidence, but I did produce them, and I confirmed that in my testimony on pages 170 and 171 of the June 11 hearing. Now, and again, the appellee's brief said there was no evidence of what was my original income in 2006, but Exhibit 8 clearly confirmed my income in that year was $88,000 plus, whereas in 2020 and 2021, I sustained a loss. Now, I do want to talk about the allegations of unaccounted for funds. The appellee's brief argued that I possibly received as much as $674,000 from my father, and that there were $382,000 of unaccounted funds. There's no evidence, absolutely no evidence that that happened. That was based entirely on a misinterpretation of the application when I was applying to become my father's guardian. After 2 years, I become his executor. He passed away, I applied to be his executor, I filled out a form. He had, as you can tell from the record, lots of accounts, but the 2 years that I was his guardian, he had dementia.
When you came to the final hearing, in this case in front of Magistrate 4, had the estate been wrapped up at that point in time?
Yes, the estate was wrapped up on December 21 of the previous year.
Did you submit his final account to the court to show where all that money went?
Yes, I did, and it was approved, and I was discharged as the fiduciary.
Probate court, I'm sorry.
The
Not
probate
probate
court.
court, but the domestic relations court. Did you submit that final account to domestic to say, here's where all the money went?
I put that into discovery, and I believe it was marked as exhibits.
You put in discovery, did you submit it to the court?
The evidence that the court accepted my final accounting and discharged me as the fiduciary was put into evidence in the domestic relations court, yes.
At the hearing before the magistrate?
That is correct.
And counsel, I need to inform you, you're into that 4 minutes, you have about 3 minutes and 15 seconds left. You can proceed or reserve as you see fit.
Well, unless there's more questions on what we've covered so far, I'd be pleased to sit down and keep my remaining time. Thank you.
Good morning. May it please the court, I'm John Donor. I represent the appellee, Catherine Dipalma. I have a lot to say, and if I talk too fast, just slow me down. This is not a spousal support case. Attorney Whipple argued in merit brief, in his reply brief, and today this is about spousal support. Judge Stevenson hit the nail on the head. This is a discovery case. This is a lack of discovery by Attorney Whipple to the trial court and in discovery. The hearing on his motion to modify spousal support was first heard in October 2021. After about 30 minutes, it was adjourned and rescheduled for January, and the court issued a specific discovery order. That order said, November 1st, we will exchange a list of documents we need from each side. We both did. I gave a formal discovery request to Attorney Whipple, who was representing himself at that time, and he gave me a request to supplement my client's hundreds of pages that she had supplied the previous July, which she did. We had to produce those by December 1st. Catherine Dipalma produced all of the requested records. There's no dispute about that. Douglas Whipple, on December 1st, produced not one single document. On December 9th, he started on a path of asking for my client to sign he called it a confidentiality agreement. Not a protective order that the court could hear and determine, but even when he asked for a protective order, it was to the extent that he self-generated a confidentiality agreement, whatever purpose it would serve, and one of my clients to sign. Of course, she refused. The court denied his request. He still didn't produce the documents. So after December 9th, on December 9th, I requested in writing that before I file a motion to compel, that he produce the documents. He produced some documents. A few account statements he produced. Not nearly what was of the 31 requests. I filed a motion to...
When you say account statement, do you mean from his bank account or from the filing to probate court?
We had 31 requests. We asked for the probate financial filings in both the guardianship and the estate, and there are numerous. There are nine inventories he filed in the guardianship. Had he not filed the initials stating everything his father owned and the value when he was the guardian of the estate, I think it's 2111.14 of the revised code, requires the judge to issue a notice giving him 30 more days, and if he still doesn't file that extensive, detailed inventory, then the judge has no choice. He shall dismiss the guardian and select another. So Mr. Whipple stayed as the guardian for all 34 months the estate was open, the guardianship was open. So he didn't produce the guardian record showing the extent of what his father had. He didn't produce anything from the estate contrary to his recent assertion. He produced one statement. It was the final, it was the sheet of receipts and disbursements, final receipts and disbursements. It was the mop-up. It wasn't the cumulative, here's everything we got in the estate, here's everything else he had. It was just the mop-up, here's what's remaining, here's what was distributed. One page, that's it. In the estate, he filed an inventory, 4 schedules of assets, 4 fiduciary accounts, all with exhibits and attachments, and he wouldn't produce those. Those are not available to the general public or attorneys like me who come into probate court and say, hey, give me this confidential information. But Douglas Whipple was the attorney for the guardian, and he was the guardian of the person and estate. He was the attorney for the estate. He was the executor and fiduciary of the estate, and he was the primary beneficiary of the estate. By the time he came in and he said on the application to administer the estate, he didn't say a round number that people sometimes do if they don't know what their parents have. They come in, oh, they have $100,000, I think, about in this account, and the house might be worth another $100,000, and so there's $200,000 there. No, he came in very specifically on that, and he said $716,000, a very absolute number. Why? Because for 34 months and 9 inventories, he knows what his father had. It was his job and duty under the law to know what his father had, and still he did not produce that to us in discovery.
When you got to the final hearing in front of Medgar,
Yes.
were you at that time able to ascertain any certainty what he earned from the guardianship of the estate?
No, but I will point out this, and neither was the court, but we'll point out this, that 3105.18 spousal support statute provides that the court will award spousal support from the property or income or both of the payor in gross or one payment or installments or both. So if he has money, and there's about $425,000 that's unaccounted for, if he has any of that money, the trial court needs to see that as part of the picture of determination, and even if the court says there are no earnings from this, the court has the ability to go in and say, we will make a final spousal support payment of X number of dollars out of the property of Mr. Whipple.
Counsel, what difference does that make when the court found that there was not a substantial change in circumstances? In other words, go home, we're not even going to talk about spousal support because you're asked to terminate and pursuant to the order, you have to have that change of, you have to acknowledge that is said that to be a change in circumstance is retirement. So what difference does it make what property he has if the court has already determined he doesn't get to have this hearing because he doesn't have a substantial change in circumstance?
His retirement at age 65 can be a consideration, but the court also found that he did not show that he was actually retired.
Right, and it says shall be, right? In the divorce order, it says his retirement at 65 shall be a change, considered change in circumstance.
That's right.
And when the court finds that he did not retire, that's what I'm reading from what the court's order is. And sometimes there's no change in circumstance. Why aren't we done?
Because a change in circumstances does not automatically reduce the support, that just gets the argument before the court.
Right.
So there's nothing that, we're painting a picture. And to borrow from Shakespeare, I believe that he's hoisted by his own petard. He doesn't give the information that gives sufficient information for the court to determine whether spousal support should terminate. So even if we are there, and even if we are saying, okay, there's been a change in circumstances, let's hear the argument, we don't have the picture of what he has. He won't give us that information. Contrary to what he said, he did not produce these statements and that were required. He did not produce anything except one page from the last disbursement form that he filled out for probate court in the estate. He did not fill out the guardianship information. He had every opportunity to. He is an officer of the court, and he has the obligation. He's got an obligation regardless to properly respond to discovery, and he did not do that. He did not do that once the court overruled his motion for protective order and request for the confidentiality agreement. He did not respond when I asked him, as I'm required to do, to produce those documents. He did not respond and fully to the discovery. I filed a motion to compel, and I attached to the motion, it's in the record, a spreadsheet of multiple pages, item by item, of what was requested and what he actually did send over, and it shows the gaps. The court granted that motion, and he was ordered compelled to produce those documents. He didn't produce those. He didn't produce anything from the guardianship. What he said, what eventually his attorney said, is that, and as part of one of the motions, Mr. Whipple has 6 boxes of documents from the guardianship in his basement at his home in Cleveland Heights, and you're welcome to go there and go through them, but I don't think those will be helpful. And that is absurd. And I said it was absurd, and if he doesn't want to produce documents, he doesn't want to produce those. I filed, after he didn't produce them again after the order compelling him to, I filed a motion for sanctions. Part of the court's decision is awarding sanctions. I spent over 30 hours, unbelievably, over 30 hours in the month of December 2021 on dealing with Mr. Whipple directly, his co-counsel with his attorney, and with his attorney on discovery issues. All he needed to do was produce it, and the court would have it. We could all make our arguments, and the court could determine, no, it looks like he's retired, or he didn't get any other disbursements.
So in this case, you would certainly say that he had not met his burden to show a change of circumstances due to his unwillingness to comply with discovery.
Yes, and he did not show, once the court opened that up, if the court did open it up, he did not even indicate the basics. Okay, here's where it was, and here's where it is now as far as income and assets go. And that's fundamental to determine whether it should stop. So the court is hearing it, but it doesn't mean that it should automatically terminate.
You would agree that if he could prove, and I'm not saying for you to concede that he did, but if he could prove he was retired, that would be a change of circumstance and would trigger an analysis of what his financial circumstances are under 310518 and whether or not it'd be appropriate to modify support based upon those circumstances.
Yes, I would. I'd agree with that.
And you would agree also that if you went back to court and filed again and then proved it, then that would be an appropriate place to go to the domestic relations court and cooperate with the discovery process and in fact prove your charge.
Yes, and in fact, the trial court stayed part of the sanctions. They stayed his ability to file any further motion to modify or terminate support until he complies with the discovery. That was a year ago.
And is that why he has an objection, magistrate erred as a matter of law by focusing on the defendant's petition for retirement and earning capacity rather than the defendant's decision to retire? The trial court found that moot, and I have a hard time following that. The trial court found that that objection was moot.
I don't find that difficult at all. They switched around the order, and when they realized there is not enough information to be able to determine what spousal support should be or whether it should terminate, reduce, increase, or anything else, then they came back around and said, we don't have the information regardless, so it's moot whether or not we have a change in circumstances. They reversed it. They reversed their analysis and said, there isn't any information if we do rule on this, so it's moot.
See, that kind of goes back to my prior questions about the finding of no change in circumstances. You mooted it, the court turned it around and mooted that out, right?
Yes.
Okay.
Yes. The trial court was mindful of, and I'll point out to the court, in this self-generated sheet, that's really what we have, is this, it's our Exhibit 23. It shows select things. There's lots of checks that are not accounted for. We're taking his word, there's no bank account, there's no backup. It's somebody who has a dog in the fight is giving us the information and saying, well, this is credible and reliable. But keep in mind, even with that, it shows in 2020 and 2021, he received $271,125 from the estate and guardianship. $271,125. That's $135,000 some change per year that he received on average for those 2 years that he is saying there is a change in circumstances. So even by what he says, the court can get to the point, yeah, you say there's a change in circumstances to bring this matter before the court because you claim to be not retired, but the fact is you have received $271,000 in these 2 years, and by your own a form that you filed as the attorney for the estate, you said there was $716,000. Where is the rest of the money? There's these big holes that he did not provide. And I think that is the essence of the case. This is a discovery case. If the court has the ability to do it because it says, that is a change in circumstances. It's not a change in circumstances. That has a phrase that that terminates his spousal support, that lowers his spousal support. It is a change in circumstances that gets the argument to the court. And so I think the trial court was proper in determining he didn't produce the information that we needed, so regardless of whether he has this. So I believe, for those reasons, the decision of the trial court should be upheld.
Thank you, Counsel.
Thank you, Your Honor. With no disrespect to Attorney Dillner, who I've known for many years, he's a fine lawyer, very little of what I just heard is in the record. But let's talk about what is in the record. Judge Hunter, to your point, the reason why it was mooted, the issue of assignment of error, number one, it was mooted, is because the magistrate concluded inappropriately that I'm not retired until the Ohio Supreme Court says I am retired. That's not what the divorce decree required, and that's not what the law requires. A lawyer is not required to get that piece of paper from the Ohio Supreme Court in order to be retired. Many, many lawyers retire all the time without formally retiring. She made a mistake, and it was wrong for her to moot it, and that reason, for that reason alone, this case needs to be reversed and remanded. Now, let me go on to, Mr. Donor said I produced only one page and that I did not produce the records. Let's see what the record does show. If you look at magistrate's finding, paragraph 37, it confirms I produced to Mr. Donor over 800 pages of documents, 600 pages of documents, forgive me. And then, and this is what's more important, let's go to what was said in paragraphs 42 and 43 of the findings, and that was that it was not found that I had not turned over the probate records. What happened was the magistrate was distracted by Attorney Donor's written closing brief. It didn't talk about that there were no probate court records. It didn't establish it. There was no evidence that I didn't. The evidence was I proposed lots of records. He tried to prove his case. He tried to prove his case on the innuendo that there was $380,000 of assets missing, and the proof of that is my estimation, which Mr. Donor himself acknowledged when he was cross-examining me, was an estimate. He said it was an estimate. All he's saying to you is that I either knew or should have known all of this about all these funds, but that's not in the record, Your Honors. So, what is in the record is the only reason why the magistrate felt, and this goes back to paragraphs 42 and 43 of page 8, the only reason the magistrate felt I hadn't produced enough of the records, or the right records, is because of the $380,000 that supposedly is unaccounted for, which he said in his brief, that constitutes funds received by Doug Whipple. Now, if you look at the manifest weight of the evidence, there is no evidence whatsoever that I received $380,000 from my father's account inappropriately. And this,
Counsel, I need to let you know that you have utilized all of your rebuttal time. In fact, we're a little over time at this
Okay.
point.
well, let me simply say, are there any further questions?
Seeing none, thank you.
Thank you very much.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be sent to all parties to this appeal, as well as posted on the El Paso Supreme Court website. We are adjourned until our next scheduled